Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
I'm Kyle Nazareth, the Marketing and Content Manager at Napa Legal.
Thank you for joining us for another episode of the Napa Legal Podcast. So if you enjoy the content we're putting out, as always, we appreciate it if you like the podcast, subscribe to our channel on YouTube, Spotify, wherever you're listening from. If you want to support our work, we appreciate your interest following what we're up to, your financial support. You can do all of that and more at www.napalegalinstitute.org. So this week we'll be covering first Michigan, the state of Michigan's, it looks like their full-scale retreat from their law banning counselors from certain types of talk therapy involving gender dysphoria. More on that in a minute. Then we'll go to the 11th Circuit. There's a ruling there upholding Florida's Protection of Children Act, which criminalizes the admittance of minors to adult performances like drag shows. That law was upheld. And then we will finish in Oklahoma with basically St. Isidore's Charter School Round 2. Different charter school, same legal argument, probably headed back to the Supreme Court. All right, so let's start in Michigan. This is pretty straightforward because this is just precedent being applied to another case. This is based on a Michigan law that was enacted in 2023. This will sound familiar to you. We'll get to that in a minute. The law in Michigan basically punished therapists, counselors from engaging in talk therapy that would help children with gender dysphoria to actually accept their God-given sex and all of that. So counselors who would have helped children work through their gender dysphoria or other related issues, instead of, recommending and supporting gender transition, would have their licenses suspended and taken away, potentially fined up to $250,000. Pretty severe stuff. So Emily McJones, I believe her name is, which is one of the plaintiffs in this case. She's a Catholic therapist in Michigan. After years of serving suicidal teens, very troubled teens in Michigan, she opened her own practice. Some of her clients were children who were uncomfortable with their sex and were experiencing some of these LGBT type issues. So the therapist she would talk to these children, help them work through the underlying causes of their discomfort, help them accept the realities of their body, their sex, and so on. You would think this is the kind of thing that therapists are supposed to do. But this law clearly conflicted with the way that she was doing this therapy. So together with several branches of Catholic charities in the state of Michigan, the therapist here filed a lawsuit against the state of Michigan on the grounds that the law violates freedom of speech, free exercise, parental rights. This was eventually resolved on free speech grounds for issues that reasons that will become obvious in just a second. So the district court lawsuit started in 2024. Michigan, I think it was the Western District of Michigan, but the federal district court refused to block the Michigan law. Beckett appealed to the Sixth Circuit. The circuit court issued a permanent order barring Michigan from enforcing the law. I think there was some talk about cert appeal, but eventually the cert was granted in Childs versus Salazar, which is the Colorado case that sounds exactly like this case. And so the Sixth Circuit case was stayed pending the Supreme Court's resolution in Salazar. So recently, I think it was just a couple weeks ago now, the parties in the Michigan case agreed to a stipulated permanent injunction that ends this case altogether. So this is kind of what you'd expect, right? Childs versus Salazar, the Colorado law was almost identical, banned certain types of talk therapy that encouraged children to accept their God-given sex, but encouraged the kind of therapy that would tell kids to go explore and affirm all kinds of disordered behavior regarding sex and sexuality. That was struck down by the Supreme Court, saying, yes, that's viewpoint-based discrimination and impermissible, prescription against free speech. So that's what happened in Salazar. After that case came down in Childs versus Salazar, the parties here in Michigan agreed, okay, this is right on point. And so the application of this Michigan law on talk therapy is also pretty obviously unconstitutional, right? So just a couple brief notes. First of all, you always worry when there's a stipulation or a private settlement or something of that matter that it doesn't create binding precedent. But the interesting thing here is that the stipulated agreement is not just that this law in Michigan is unconstitutional as applied to um, McJones and those Catholic Charities plaintiffs, but it's pretty clear that well, I'll just read it in the stipulation. The court hereby declares that HB 4616, that's the talk therapy law at issue in Michigan, as applied to licensed mental health professionals engaged in therapy that consists exclusively of talking, violates the free speech clause of the First Amendment. So this is somewhat precedential. The court is saying, listen, at any time you just can't apply this law to talk therapy. Same as the outcome in Childs versus Salazar, it applies here. This Michigan law can't apply to talk therapists. So again, not much more to say on this. I'll just make two quick points. I think there was just really no other reasonable outcome after Childs v. Salazar because the cases were just so similar. But one, always worth pointing out that it's so important that Christians or people involved in these important, cultural issues not lay down and give up when faced with these legal challenges. It can be kind of daunting, right? You're just a Christian therapist with a little private practice, and all of a sudden, you're facing Michigan law. You might be facing investigation from the Michigan Attorney General. In some cases, in other situations, you might have a lawsuit where like the ACLU comes down against you. It just feels like such an uneven fight that people tend to just want to back off, lay down, right? But it's so important that people on the right side of these issues not lay down, right? One case with good facts, like Childs v. Salazar, is not just defending one therapist in one state. In this case, right, it creates the precedent to shut down these kinds of like anti-religion, anti-nature laws all across the country, right? If Miss Childs hadn't fought in Colorado, then who knows what Miss McJones here would have had to deal with in Michigan, right? So sometimes the one precedent overturns a lot of similar laws and prevents a lot of unfortunate situations all across the country. So if you're the first and you have good facts, take up the fight. And as we probably remind you pretty much every week on this podcast, there is help out there, right? It's not hostile governments and hostile law firms versus little old you. We have a lot of really good law firms like ADF and Beckett and Thomas More Society and First Liberty who will often come in with guns blazing and help to really make sure that your religious rights and other related rights are protected. So important to see what your options are and not just lay down if you find yourself the unfortunate target of something like this. And one other point, I still remain curious. I've discussed this in the past on similar cases here with the talk therapy issue in particular, but I remain curious and a little bit concerned to see how the opposite case would play out, right? I'm not sure off the top of my head if there are any states that have explicitly banned talk therapy on the other side, right? Talk therapy that encourages children to explore, unnatural lifestyles and sexual practices and identities and all that. Obviously, we've seen bans upheld on so-called transgender medical procedures, right? Like the Scrutiny law, the Tennessee law in Scrutiny, where the government has said, no, there's an interest. It's not, right. It's not a protected speech. This is a medical procedure that is harming children. And so a state can indeed ban that. Excuse me. But I've never seen a law banning bad versions of talk therapy. And I'm frankly concerned that such a law would probably still be struck down as viewpoint-based discrimination on speech, even though, in my view, such a law is pretty clearly for the common good and would protect children from an ideology that does them harm. But that's the difference in how these, like where we are constitutionally, right? What are the limits of what we can do under current jurisprudence, right? If what we're focusing on is the government can't prefer one viewpoint over another in most situations and ban one viewpoint in an area of speech but allow the other, then that's helpful when a state does something crazy, right? Like banning therapists from helping children to accept their God-given sexuality, right? We obviously don't want a state to have the ability to ban that. But for me personally, if you have the opposite, a state that says, no, therapists are not going to be able to harm children by telling a confused teenager that he can become a girl or what have you. If you're, in this kind of neutral viewpoint-based discrimination jurisprudence, I think that statute probably gets struck down as well. So I don't know if I have like an easy answer, but I do see a problem when the kind of neutral viewpoint discrimination, content-based discrimination theory cuts both ways and can end up striking down laws that I think are good. But I guess for now, I'll leave it at that.
Yeah, I couldn't agree more, Frank. And we've talked about this a little bit before, and like you said, similar cases, but it really has to do with the broader question of, well, are we going to acknowledge a moral basis for some of this free speech jurisprudence? And maybe there are some kinds of good viewpoint-based discrimination and good content-based discrimination and vice versa, right? And acknowledging that kind of moral distinction.
Sorry,
Mhm.
one thing to interrupt, but like
Go for it.
this becomes very practically dicey from a policy perspective because I don't want to go down the like you can be in principle correct, right? That there are some kinds of viewpoint and content uh, angles that should be banned because they're bad. But when our culture, our governing class are not really to be trusted necessarily to interpret what is actually for the common good and then what is not, then it's not illegitimate to say, oh, we're kind of concerned with opening up, certain viewpoint-based discrimination, right? Like the government can ban this kind of viewpoint because it's against the common good. It's like, right, in theory, I'm with you, but in practice, I don't know that we have a ruling class that I trust with very much power. So I probably sit between the two principled extremes of, process-oriented, completely neutral, and very morals grounded lawmaking because I'm probably with the latter in principle, but I don't know that I trust the regime that we have to actually implement it. We'll leave that
Yeah.
there.
No, that's a good prudential distinction because especially with the scope of constitutional rights now they touch on almost everything or certain sides want them to touch on almost everything rather than leaving them to localities or states, right? That's very, very true. I don't know if I trust people in the federal government to decide some of these things, but that is a good segue into our next case, a case where the 11th Circuit, sitting on banc actually, upholds the Florida Protection of Children Act against First and 14th Amendment challenges. So yeah, another example of constitutional rights touching on a local state kind of statute. And this law was passed in 2023, and it makes it a misdemeanor actually for a business to knowingly admit a child to an adult live performance. And that's defined as a show before a live audience that depicts or simulates nudity, sexual conduct, sexual incitement, specific sexual activities. It's defined that in another part of the statute, and also lewd conduct or the lewd exposure of prosthetic or imitation genitals or breasts. I never thought I'd end up saying that on this podcast, but it is what's the subject matter when it comes to basically drag shows is what this statute is targeting, and the penalties are per violation are up to a year in jail, a $10,000 fine, and the loss of a business license. And the statute is actually very necessary because Florida has had multiple problems with drag shows in the past. Um, just last December, Zach Smith from the Heritage Foundation's Meese Center, he flagged something called a drag queen Christmas. And this show was booked at the Sanger Theater in Pensacola on December 23rd, 2 days before Christmas. And in the article, he kind of writes, he says that the male performers use demonic imagery, devil costumes. There's crude anatomical jokes on some of their names, and they have a lot of profane kind of things they say about Israel and ICE and those kinds of things. So this is really more than just about disordered displays where men pretend to be women. It's actually really the targeted mockery of Christianity and in a venue where children could be possibly exposed to this kind of indecency as well. So a little bit of the backstory additionally is that the Florida AG, James Uthmeyer, he wrote to the Pensacola City Council telling them to cancel it pretty much and citing some, obscenity laws and these kinds of things. And I don't think the city ever did, but after this en banc decision, they might reconsider and give second thought to these kinds of events. And just getting into the court ruling really stems from this incident. A challenge was brought against the statute by Hamburger Mary's, a bar and restaurant chain that hosts drag performances regularly, and those had been open to children. And the legal argument they're kind of bringing, well, first, it's a pre-enforcement facial challenge on they're kind of arguing First Amendment overbreadth and 14th Amendment overbreadth and vagueness grounds as well. And they're really targeting two phrases, the statute's use of the word lewd and the age of the children present, that phrase. So the federal district court originally granted a preliminary injunction that applied against everyone in the state. So it was a universal injunction, right? And the district court said the injunction was necessary to protect all Floridians. A divided panel at the 11th Circuit then affirmed the lower court, and then this en banc court vacated the panel opinion, granted rehearing. So just reading through the opinion, there are some interesting arguments about universal injunctions, and the opinion says federal courts can't issue them pretty much. And that's according to the 2025, excuse me, the 2025 Trump versus Casa case. There's also an interesting kind of statutory construction argument regarding why the use of the word lewd in the statute isn't vague or overbroad. There's discussions that brought me back to law school and leg reg about interpretation and nocitor associis, but for now I'm going to leave those discussions and the deeper dive to all the reading law enthusiasts. What I really found most interesting in this opinion was that it reestablished that obscenity is outside First Amendment protections entirely. The court says the First Amendment has never treated free speech as an absolute, and that there are certain well-defined, narrowly limited classes of speech which have never been thought to have constitutional protections, and that it's categorically settled that obscenity is one of these classes of unprotected speech. And the court relies on Free Speech Coalition versus Paxton. It's the first time I think that case has been applied in an en banc setting. And they kind of talk through the Miller for minors test. For those who want to go into it, it's, I think, section 3B of the opinion. But they basically say that these restrictions on obscenity from a child's perspective trigger no heightened First Amendment scrutiny, and that they're only subject to rational basis review, even though they could also encompass speech for adults. And that basically once speech is classified as obscenity, courts don't weigh interests, strict scrutiny is never applied, only rational basis, which means that the law will almost always be valid. And writing for the majority, Judge Andrew Brasher describes the act as a straightforward regulation of obscenity, explains that keeping children out of adult performances that are obscene is rationally related to Florida's interests. And then after the decision came out, Florida AG he's the one who, or his office is the one who defended the Protection of Children Act through the en banc hearing. He tweeted and celebrated the ruling and said the law rests on settled obscenity doctrine, not a novel theory of state power over speech. And this is absolutely true because free speech has never been unlimited in this country. The American history of free speech is one where it's not completely unlimited. For example, right, the Sedition Act of 1798 with John Adams, that makes it a crime to publish false, scandalous, malicious writing against the U.S. government, the president, Congress, those kinds of things. Well, whether I personally disagree with the signing of that act is kind of beside the point. It really demonstrates that the history and tradition of free speech jurisprudence means refusing some constitutional protections for certain kinds of speech in the country. And again, this is reiterated in 1942 Supreme Court case, Chaplinsky versus New Hampshire. They held that certain categories of speech, including lewd and obscene speech, profane and libelous speech, and insulting speech or fighting words, doesn't serve constitutional protections. And that's not even a political issue, really. Justice Brennan in Roth versus United States said the exact same thing, and he's not exactly a flaming heart social conservative. And so that kind of just leads to the logical conclusion of, well, our tradition of free speech in America requires us to kind of acknowledge that it's not unlimited and that we need prudent censorship of certain speech, including restoring prohibitions against obscenity. And in this case, that was rightly determined. And again, that leads to an interesting question that we were talking about earlier, Frank, in the last case of, well, how do we determine what speech is good or bad and what speech doesn't get constitutional protections? Well, Columbia law professor Philip Hamburger has actually pointed out a guiding principle that prior to 1798, almost all Americans who asserted the right of free speech weren't making arguments that seditious libel, defamation, obscenity, or fraud were protected constitutional speech. The citizens understood that free speech was a natural right, actually, and natural rights were understood to be subject to natural law and retained under civil government only to the extent permitted by the Constitution and other civil laws. So, what Professor Hamburger is acknowledging or talking about here is that there's a moral influence of natural law on positive law. And that's kind of why John Adams writes, our Constitution was only made for a moral and religious people. It's wholly inadequate to the government of any other, right? The founders were natural law proponents, and we can see that in the Declaration of Independence and the constitutional ratification debates, where they're citing Aristotle, Plato, Cicero, Blackstone, right? All these natural law thinkers. And I think we really need a natural law revival and education about what natural law is in order to understand eventually what our liberty and free speech actually entails. And just capstone on this kind of point, there was a great article published today in Anchoring Truths, James Wilson's Society's outlet or platform, and it really touches well on the relationship between natural law and positive law, and that both are law, and we need natural law as well.
Yeah, thank you. That was that was my article. Just for the record, written in my personal capacity, so that was not on behalf of Napa Legal, but that's a fun examination for people who are interested in the potential role of natural law in an American jurisprudence. I think I proposed something modest and worth engaging with. But I'll just say too that it's not even this should be completely uncontroversial. This question of among conservative legal minds. This is not a matter of whether you're like a natural law jurisprudence or advocate or an originalist, because this kind of case is so easily defended on originalist grounds too, right? If you're looking for the original public meaning of the law, right? What does free speech mean? The right, free speech can't be abridged by the government. Free speech, the words meant something, and the words free speech did not include obscenity, libel, fraud, etc. That's pretty clear. So I think it's always worth reframing and fixing this, because people who will argue for, free speech rights to have drag shows in front of children will, I think, disingenuously, maybe just ignorantly argue that, well, you're trying to abridge, speech and freedom of expression and American values and blah, blah, blah. But that's not what free speech meant. That's not what American values are. That's fairly obvious with even a basic understanding of American history and law. So I find it really important to correct the record on things like this and say, no, you can be a robust defender of the First Amendment of free speech and be adamantly opposed to, allowing for obscenity, because the two things are just consistent. And so I strongly object to being told that, to have anti-obscenity laws means that you're anti-First Amendment, because that's just wrong as a matter of fact.
Yes, exactly. Natural law and originalism or textualism don't conflict. They actually work very well together.
Yeah, there's a little bit of need to find the place to come. What am I trying to say? There's a little bit of distance between them on some hard cases, which is why I wrote that article. But I think, yeah, we can get a little bit lost in the weeds of principle and make those fissures seem wider than they are. But getting us back, let's wrap up with this last case. This should be a pretty quick one, because there's another one that will sound familiar, just as our first case with Emily McJones might sound a lot like Childs v. Salazar, because it was. This case, it's a Jewish charter, well, a Jewish school foundation asking for charter school status in Oklahoma, which may sound a lot like the St. Isidore's virtual charter school case that went up the Supreme Court, last year? And that's because they do sound the same. They are virtually identical legal cases. So as a lot of listeners will already know, Oklahoma has a charter school program. There's now a Jewish school, the National Ben Gamla Jewish Charter School Foundation. They started the school. They tried to apply to join the charter school program in Oklahoma. This case went up to the Oklahoma Supreme Court was denied for the same reasons that the Oklahoma Supreme Court denied St. Isidore maybe 3 years before. So this Ben Gamla school, represented by Beckett, filed a lawsuit challenging the exclusion of faith-based schools from the charter school program. So again, there's not a lot to say here that is new. You can go back and find our work that we've done on the St. Isidore case, and you'll get all the legal backdrop. And particularly, if anyone's interested, I interviewed Chris Shondavel at Alliance Defending Freedom, who is also the brief writing ninja, one of the best legal follows on LinkedIn. So last May of 2025, I interviewed Chris, and we talked about this First Amendment issue with the Oklahoma charter school system. So I'd encourage you to go back and listen to that episode, and you'll get a lot of the background. But basically, I just want to note a couple of things. For one, every state's charter school system is different, sometimes quite different. So it's worth pointing this out for people who are not familiar with Oklahoma. If you're familiar with other states, like where I am in Pennsylvania, charter schools are essentially like a public magnet school, right? They're run by the government. They're publicly funded by the government. That's more like a public school. And so if you heard, well, religious charter school, and you're in one of these public charter school states, this would sound more shocking than it actually is. Oklahoma's regime is quite different. Charter schools they're privately run, right? They have their own, they're founded as a nonprofit. They're run by a board that's independent of the state. And then they contract for charter school status and they receive some state funding. But they're private schools. They're not public schools. So in my view, and I don't think just in my view, this was Chris Shondavel's view as well, but if you understand what the Oklahoma charter school system is, the reasoning in Carson v. Makin, which you'll remember, is if you have a publicly available funding benefit, right? In that case, it was school vouchers, and you say all schools that meet certain criteria can participate in this funding program for vouchers unless they're religious, right? Religious schools cannot apply. Supreme Court said, no, there's no need to do that under the Establishment Clause, and therefore excluding schools solely for being religious is a free exercise violation. You actually cannot do that under the First Amendment. The way I see it, if that's true of the voucher program in Carson v. Makin in Maine, it's also true of this private school charter contract in Oklahoma. If all kinds of schools can apply if they meet certain criteria, unless you're religious, that doesn't seem to fly post Carson v. Makin. I don't see what distinction you can make between the Oklahoma charter school system and the Maine voucher program that would distinguish yes in Carson, no in Oklahoma. So I think that should be the way that this case goes. I think allowing religious charter schools in Oklahoma is frankly the natural result of the Carson v. Makin case and Trinity Lutheran and some of the other cases that came before. And I hope this case is ripe to go up to the Supreme Court and do what St. Isidore didn't do. I think, again, everybody will probably remember this, but everybody in the kind of religious liberty movement was very excited that St. Isidore was going to be the next big case on this issue. And then cert was granted and Justice Barrett recused herself for personal reasons. We can only guess at what those were, although we've probably opined on what those reasons might have been in speculation on this podcast in the past. Anyway, assuming that Justice Barrett does not have to recuse herself on this Ben Gamla case, I think the case has a pretty high likelihood of going 5-4 in favor of the school receiving charter school funding. I hope that's the case. I hope this is the case to do it. It will also be interesting for the legal nerds among us because this will basically flesh out who voted which way in the St. Isidore case. Because if you remember, right, without Justice Barrett, you only had 8 justices. It was a 4-4 decision. So you get like a 2-line per curiam that says, for the vote split 4-4, and therefore the lower court decision from the Oklahoma Supreme Court stands. There was no precedent, and we also didn't have any indication of who voted which way in the St. Isidore case, right? So we can make pretty good predictions, but assuming that 3 of the justices, and again, this is only speculation, but the 3 of the justices who were against St. Isidore receiving charter school status were probably Justices Kagan, Sotomayor, and Jackson. There are interesting questions about who the 4th would have been with Barrett recused. Was it the Chief Justice? Was it Kavanaugh? Was it Gorsuch? We don't know. I know the biggest speculation was that the Chief Justice Roberts, who doesn't like to upset, Supreme Court's reputation for being fair and not radical and what have you. But I don't know. Again, this is all speculation, but Chief Justice Roberts wrote Carson v. Makin. He also wrote Fulton versus Philadelphia. Um, I would be fascinated to see the reasoning from the justice who wrote Carson v. Makin to vote against a case like St. Isidore or now Ben Gamla. So I'm kind of hoping this goes back up and we can actually see, well, hopefully we get a good result, but also we can see where the lines fall and who is voting which way and on what reasoning. Because again, not to repeat myself too much, but I don't see how the reasoning in Carson v. Makin doesn't lead you naturally to supporting religious charter schools in Oklahoma. And one last note, even within Napa Legal and our friends and circles, there are split opinions about whether this is a good idea. So I just kind of distinguish that this is about getting the law right. I think that as a constitutional matter, religious schools should not be excluded from otherwise generally available funding programs, right? Just on basic free exercise grounds. But it is worth hesitating and cautioning schools to consider, right, what strings are attached, what comes with taking state funding. So we're saying that as a matter of the Constitution, it certainly should be the case that religious schools can participate in these programs, but that does not mean that all religious schools necessarily should. It is a more complicated question than that. And we'll keep an eye on this and see where this case goes, but this may be the next big case in this area, so we will stay tuned.
Going off that, Frank, I think that's an important thing to acknowledge because that tees up a Supreme Court case that the Supreme Court's already granted cert on, which is the St. Mary Catholic Parish case, right? And that involves a Catholic preschool asking the state of Colorado to be exempt from some of its SOGI or sexual orientation, gender identity rules. And exactly what you said, there's going to be some strings attached to charter schools, especially religious charter schools, getting money, and states have other rules or statutes that often conflict with that. So we'll have to keep an eye on that case and see whether hopefully religious schools get an exemption, even if from SOGI rules, even if they do get money from the government.
Yeah, no, that's a good point because when you're talking about the strings that would be attached to state funding for religious schools and organizations, that's the biggest fear I think that most religious organizations and advocates for religious freedom have is that, yeah, are you going to be forced to toe the line on whatever the state's non-discrimination requirements are in hiring and applications and student acceptances and so on. So you're right. It's a good point to add in that St. Mary's v. Roy will actually be a really important answer to that question of what strings can be attached if the government does go ahead and say, yeah, religious organizations can apply, but you have to do XYZ. What XYZ is can be pretty scary. And yeah, St. Mary's v. Roy will be a good answer to that. And with that, we thank you for joining us for another episode of the Napa Legal Weekly Podcast. We hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religion and the work of faith-based nonprofit organizations in America. So we'll talk to you next week. Thanks for joining us, and God bless you all.